everybody. I'm John Giardinelli. I'm Association Counsel, and this is John's Rants. We're going to do some things a little bit differently over the next couple of rants. Today, I'm going to cover something that came out of the Department of Real Estate because all of you, regardless of your situation, need to have a license, and losing your license or having it suspended is a very bad thing. So I want to talk today about what the DRE claims are the most important areas to be aware of relative to violations. Then we're going to do another rant in just a couple of weeks, and that's because the California Association of Realtors meetings are coming up in San Diego, actually Chula Vista, and we're going to do a post-CAR update on the new December forms, on the update on the bulletin that came out regarding escrow disbursements, and a whole panorama of other issues in addition to some other things that are coming up fairly soon. So with that in mind, I want to talk to you today about a topic that's critically important. I've over the years defended quite a large number of Department of Real Estate accusations, and also have responded to letters to brokers and to agents regarding claims that consumers and others have made regarding the conduct of the realtor. Now, this is different than a code of ethics issue, although very similar. The Department of Real Estate takes the position that it must have evidence of a violation before it will proceed. And so the first step is going to be an investigation. If you ever get a notification that you're being investigated for any reason, it is critically important that before you speak to the Department of Real Estate, you speak to your attorney. In some situations, if the problem is serious enough, the broker may want to bring in their legal counsel. You may all have the same counsel depending upon whether there's a conflict. But at the end of the day, you've got to take these things seriously. They can get away from you. If you're not careful, you can say the wrong thing. While the current group of investigators is headed up by some really competent people, they're not your friends. And so their position is they're there to protect the consumer. And if they've gone to the extent of writing you a letter, contacting you in order to make an appointment, it's very important. The next step, obviously, is if an accusation of any kind is filed against you, it is critically important that you follow the dates, that you respond in a timely manner, that you speak to your counsel about how you're going to respond. The first response is basically just a form. You need to notify them that you intend to defend the case. You also need to let them know that you want their file and any at least to review it or to copy it, depending upon what your attorney tells you to do. And of course, at some juncture, you want to contact them either through your counsel or directly to see if there's a way of resolving the matter, if in fact there are some problems. It's been our experience that most of the prosecutors are pretty reasonable, and we've been able to settle a lot of cases that look fairly hopeless at the beginning. But if necessary, we'll go to trial. And the benefit, of course, is that your attorney is going to be a lot more prepared than a government attorney most of the time, assuming you have the financial resources to defend yourself. But if you can avoid all that, always better try and resolve the matter, slap on the hand, something like that. So what are the violations that are going to get you in the most trouble? I'm going to go through the list and tell you what I think you need to do if something comes up. First on the list, of course, are property managers, and that's because the most charged violation is trust fund and record keeping violations, and typically that means a property manager and their trust fund. The key element here is clearly commingling. You need to be extra careful all the time that you do not commingle your business, entertainment, and personal money with the money that you are holding in trust for other people. That means that you need to have a good record keeping system. You need to be constantly reconciling at least once a month, going through your records, or having somebody that very trustworthy and good with numbers go through your records to make sure that your trust fund balances are to the penny. It's always my recommendation that you retain the services of a consultant, not necessarily a lawyer, because frankly, we're going to be a little expensive to set up a system, but there are some great consultants out there that can help you uh, set up systems, recommend programs, and do those kinds of things. So again, um, make sure that you have good systems in place, good record keeping, good people to monitor if you're not going to do it yourself, that you deposit all the money that you get quickly, that you maintain clear records of what you are depositing and what you are pulling out, and that everything be done through a qualified bank. Um, Again, the penalties can be severe if you intentionally commingle. It can result in an accusation that attempts to either take your license or suspend it. And if it's egregious enough, we've seen cases where they have actually filed for criminal complaints. So those of you that do property management understand that according to the National Association of Realtors, you're number two on the list of the most likely candidates to be sued and or brought up on some type of administrative claim. Number one are dual agents on the sales side, but you're not all that far behind. In addition, of course, to trust fund violations, property managers have to deal with fair housing issues, and of course, California is incredibly complicated and strict landlord-tenant laws that relate to evictions and all those kinds of issues. So, number two on the list, brokers, is a failure to supervise. As you know, a couple of years ago, the Department of Real Estate and the California legislature adopted programs that require that you take 4 hours of education or 3 hours of education every so many years in order to keep up. And I asked the commissioner very simply one time, so why the need for this statute? And his response was very simple: because brokers don't supervise. We see it all the time. We see it at the professional standards level where Lori Smith will get in a violation charged against an agent. And the question is always, well, should we name the broker? Has the broker done everything the broker's supposed to do to make sure this agent doesn't violate any of the rules? So there's a couple of things you need to be aware of. There's a regulation. It is a regulation in the real estate law 2725, and it lists all of the categories that you are required to supervise on. And it's very important that you understand that those categories include making sure that you maintain advertising restrictions, that you cover fair housing, that you deal with how to document your files properly, and all of that. It does depend in terms of how you to supervise on the size of your office, the number of offices you have, and the number of agents you have. So there are distinctions regarding the differences between larger offices with a number of agents and smaller offices where the broker has more opportunity to be hands-on. You must make sure that if the activity that is being engaged in by your people requires a license, that anybody that is handling a matter have a proper license, that you need to keep track of their education requirements and make sure that they stay on top of that. You need to make sure that they report any criminal conduct. I'm going to go over that with you in a little bit. And that you need to make sure that their advertising is accurate. You need to basically oversee the office. All of the clients are yours, all of the listings and all of the BRBCs are yours, and therefore it is critical that you supervise. One of the issues that comes up all the time is, well, I can't make these people go to training, which is one of your requirements, because they're independent contractors, and that is absolutely not true. Under Assembly Bill 5, which was passed a number of years ago, they carved out an exception to the independent contractor law that says if a broker is required to supervise, the broker is entitled to have training in order to make sure that his people or her people understand what the duties and responsibilities are. And the good news is there's help on the horizon. The Department of Real Estate realizes that this issue comes up all the time, and they are planning on adding to 2725 or in some other area, but probably 2725, a requirement that brokers educate and train their people, and that they understand what their responsibilities for training are. So that's coming down the road probably before the end of the year. It is critically important that you maintain, update, and have everyone review and execute appropriate policies and procedures. What normally happens is if one of your agent gets in trouble, the broker is going to get a letter asking that they provide certain information, including the training and other procedures that the office follows. So you need to make sure those are updated. Again, there are excellent consultants out there. There's all kinds of material you can obtain online, customize it for your own use, have your attorney help you with that. And of course, if one of your agents does engage in inappropriate behavior, you need to report that. And I'm going to get into that a little bit more in detail, but it's critically important that you understand that the goal of the Department of Real Estate is to protect the consumer. And if your agents are doing something that is not to the benefit of their fiduciary clients, then you need to take an action to deal with that. Another area that comes up all the time is unlicensed activity. All of you probably looked at or are aware at least of the recent bulletin dealing with escrow companies not being allowed to pay unlicensed persons out of escrow proceeds. But it's equally important that you understand that your agents must be properly licensed, and those people that are not licensed, whether they're transaction coordinators, whether they're receptionists, whoever they are, do not engage in licensed activity if, in fact, they are not carrying a current license. This issue, again, comes up a lot in escrow disbursements, but it comes up in other areas as well. And so it's critically important that you understand what is and what is not a licensed activity. I've got a couple of things I'll go over with you at the end of the program. An area that's a hotbed right now, of course, is the unlicensed assistant and or transaction coordinators. And the Department of Real Estate is working on regulations that will hopefully help you to differentiate when a transaction coordinator can act, when they cannot act, when a licensed assistant can act, and when they cannot act. Another area, the next area that I want to discuss is the disclosure of material facts and misrepresentation. Again, this is an area that probably leads the list of reasons you're going to get sued in civil court. But it's also one of the more common areas where the Department of Real Estate may come after you. And so it's very, very important that you not make false statements. And again, because of the recent settlements with some of the plaintiffs in the commission litigation, Department of Real Estate, which does not have a dog in that particular show, is also very interested in how you are disclosing the commission issues that they're that you make sure that they understand that commissions are negotiable, that you don't mislead them on how you're going to be paid, and all of those things. That's why the new law went into effect recently that requires you to have a buyer representation agreement. It's important that you not make representations that you cannot back up or that you have not verified. If you are not able or not comfortable in verifying something that you're telling your client, it is critically important that in writing, you tell your clients that you have not verified the information. In other words, that, Bob Jones told me this, and so I'm telling you, but I have not verified it. I'm not qualified to verify it. I had a case recently where there was some disclosures regarding mold eradication, mold and mold repairs. And of course, the agent was told certain information about what was and wasn't fixed. And they did a bang up job of writing to the other agent confirming, hey, this guy told me, I'm telling you, I have not verified, I'm not qualified to verify. It is a licensed activity. If you have additional questions, you or your client should contact this person directly. Things of that nature. It's just critically important you understand that a material fact, which is a fact that can affect value or desirability, be disclosed, and that's true in every transaction. The duty to be honest, but if it has to do with your own client, it isn't just the facts that you must disclose, but it's all material information. Any kind of information you get that's material. And my attitude, I've never been sued for disclosing too much information. So document your files carefully. I'm writing an article. It's almost finished. I'm holding off and disseminating it. It has to do with how you document your files relative to some new regulations that are coming down. But that article can also be used to train, assist, and confirm that you have properly documented whatever it is you need to document. I've run it by the commissioner's office. They've given me some input. So you should be getting that sometime in mid September. I'm going to be working with the professional standards department. We're going to be doing some programs on revisiting fiduciary duty, disclosure, how you go about doing its disclosure, how you use the seller property questionnaire, the TDS, and all of that. But this is the number one way that lawsuits are going to come up, where the seller allegedly and the brokers did not properly disclose defects in the property, which resulted in the buyer having to undergo expensive repairs. Again, the next issue is reporting criminal activity. If you are convicted of a crime, if you are accused of a felony, if you are indicted for a felony, those things must be disclosed in writing to the commissioner's office, the Department of Real Estate, within 30 days. If you fail to do so, you can be separately charged, not just for the crime, but also for failure to disclose the crime under the DRE regulations. Hopefully, none of you will have that problem, but if it does come up, you need to be extra special careful about disclosing that information to the Department of Real Estate, and it must be done in writing. Again, you should ask your attorney to assist you, because if you don't, you could get yourself into some serious difficulty. And then lastly, advertising. And advertising is closely related to the Code of Ethics. Article 12 basically says the same thing that the Department of Real Estate says, which is that you must be truthful in your advertising, in all of your disclosures. You must disclose your license number You must properly use fictitious business names, which is a whole class for a whole nother day. You must be truthful in the use of your team names. Obviously, there's specific statutes dealing with that. And so it's just important that that you understand that even though you are salespeople and you're going to engage in some level of puffing, that you also understand that you must be inherently truthful in your advertising. Always give yourself a little wiggle room in terms of the kinds of things you say about a property. I just got an email from a property that from a development I'm interested in, and there's a lot of stuff in there that I think could get these people in some trouble. You know, it's the best, it's the largest, it's the best this or the greatest that or the the most valuable whatever. Always give yourself its, you know, in terms of how you say things to make sure that you can uh, wiggle out of something if in fact it turns out that you're not completely accurate. So it's hard to wiggle out when you tell somebody it's the biggest, the best, etc. So be careful about the language you use. Make sure that you understand if you're going to use a team name, that you understand how those team names are to be used properly under the statute, and that you comply completely. I frankly, if I'm representing a brokerage, which I do all the time, I'm telling the broker you make sure that all of the team activities are clearly in writing, that the team structures are clearly identified, and that all of the disclosures that must be made for everyone that's within that team and the broker relationship be clearly defined so that clients understand exactly where they're coming from. So again, I'm going to quote the Department of Real Estate: educate yourself, educate your team, have strong systems in place so that things can be clear and followed correctly, um, be transparent at all times, and constantly teach yourself whatever it is that needs to be taught. Now, as far as what is and what is not to be licensed activity, we're going to be doing some stuff in the very near future, and we are working currently with the Department of Real Estate. In fact, we're going to be meeting with them in a couple of weeks to go over some of this stuff. But again, a couple of things that people can do without a license, and this comes directly from a DRE list. You can cold contact, you can conduct open houses so long as you're not negotiating terms. You can do comparative market analysis. You can communicate with the public, arrange appointments, provide access to properties, help with advertising. You can help prepare documents. You can deliver documents, and if you're a notary and documents need to be notarized, you can oversee the signing. You can communicate with the principal on specifics that do not require interpretation or advice. What you cannot do unless you have a license is enter into a listing or a BRBC agreement, take part in any negotiations relating to the transaction, discuss or negotiate terms of a contract, discuss conditions of property, discuss or negotiate conditions of a transaction, discuss legal content of a document, solicit for a specific property, transaction, or product, or induce a prospective client to engage your brokerage. There's a lot more to be said, but just to give you a quick overview of some of the things we're going to be talking about in the very near future. All right, well, that's enough for today. We're going to be heading up to the CAR meetings very, very shortly, and we'll be reporting again in a few weeks on what's going on with the new forms, which they're going to be pretty interesting, I think, and very helpful to you. We're going to be talking about some other things, and of course, we're going to be keeping an eye out for the clarification on the escrow disbursement bulletin that should be coming out in the next couple of weeks. So with that, I will say goodbye for now, and look forward to seeing y'all the next rant. Thank you very much.